This conversation is powered by Google Illuminate. Check out illuminate.google.com for more. Today's discussion centers around the Social Security Administration's guidelines on the Uniform Transfers to Minors Act, or UTMA. It's a complex area, but crucial for understanding how assets held for minors impact Social Security benefits.
Indeed. The UTMA, while designed to simplify gift-giving to minors, introduces complexities when it comes to determining eligibility for government assistance programs like SSI.
Exactly. Many aren't aware of how the UTMA's provisions interact with SSI resource limits. Can you shed some light on the initial confusion surrounding this?
The initial confusion stems from the fact that the UTMA is a state law, and each state can modify it. This lack of uniformity creates challenges in applying consistent federal guidelines.
So the federal government has to navigate a patchwork of state laws? That sounds challenging. Let's start with the historical context. The document mentions both the Uniform Gifts to Minors Act, UGMA, and the UTMA. What's the difference?
The UGMA, predating the UTMA, was more restrictive, primarily allowing gifts of cash or securities. The UTMA, finalized in 1986, broadened the scope significantly, encompassing virtually any type of property.
So UTMA is a more comprehensive and flexible approach?
Precisely. It allows for a wider range of transfers, including payments of debts owed to a minor and transfers from trusts or estates. This flexibility, however, adds to the complexity of its interaction with SSI.
The document provides key definitions. Let's go through them. What constitutes a donor in this context?
A donor is simply the individual transferring assets to a custodian for the benefit of a minor.
And the custodian?
The custodian is the adult responsible for managing the custodial property until the minor reaches the age of majority.
And custodial property encompasses?
That includes the initial transferred property, plus any income or proceeds generated from it. It's the entire pool of assets under the custodian's control.
The document emphasizes the irrevocable transfer. What does that mean?
It means the donor relinquishes all control and cannot reclaim the assets. This is a crucial aspect for SSI eligibility considerations.
How do these UTMA provisions affect SSI eligibility?
The key is that the assets are not considered resources of the custodian. The custodian cannot legally use them for their own support.
So the custodian's financial situation isn't directly impacted by the UTMA funds?
Correct. However, the donor situation might be. Assets transferred before the UTMA transfer might still be considered income to the donor, subject to deeming rules.
And what about the minor's situation before reaching the age of majority?
Before the age of majority, the UTMA property itself isn't considered income or a resource to the minor unless it's deemed a device similar to a trust. However, any disbursements from the custodian to the minor are considered income.
So it's the disbursement, not the existence of the UTMA account itself, that affects the minor's SSI benefits.
Precisely. The minor only gains full access and ownership upon reaching the age of majority.
The document mentions the transfer of resources provision. How does that apply?
If the donor is the eligible individual or their spouse, and the transfer was for less than fair market value after December 14th, 1999, it could trigger the transfer of resources rules. There are exceptions, such as if the UTMA is considered a device similar to a trust.
And what about transfers before December 14th, 1999?
Those don't affect SSI eligibility, but might impact Medicaid eligibility.
The concept of a UTMA account being considered a device similar to a trust is mentioned. Can you elaborate?
If a minor's own funds are placed in a UTMA account, it might be viewed as a trust, triggering different evaluation rules. This is a crucial distinction.
So the source of the funds within the UTMA account is critical?
Absolutely. It determines how the account is assessed for SSI purposes.
What happens if the UTMA account is closed before the minor reaches the age of majority?
That depends on whether fraud or similar fault is involved. If fraud is found, the assets are counted as a resource to the donor retroactively. If not, the gift is counted as income to the donor in the month of closure.
So intent and circumstances are key factors in these situations?
Absolutely. The SSA needs to determine the true nature of the transaction.
The document outlines procedures for developing and documenting UTMA accounts during initial claims and redeterminations. What's the key takeaway here?
Proper documentation is essential. The SSA requires evidence of the UTMA transfer, such as a deed or bank statement. Without proper documentation, the transfer may not be recognized.
And what about the CG field in the system?
The CG field is used to record the UTMA information, including the balance and the date the minor reaches majority. This ensures consistent tracking of the account.
The document provides an example. Can you summarize it?
A custodian withdrew funds from a UTMA account to pay for a child's summer camp. Because the withdrawal wasn't a direct disbursement to the child, it didn't count as income to the child for SSI purposes.
So the purpose of the withdrawal is relevant?
Yes, the use of the funds is a key factor in determining their impact on SSI benefits.
The document concludes with a list of references to other sections of the POMS. Why is this important?
These cross-references highlight the interconnectedness of various SSI policies and procedures. Understanding these related policies is crucial for accurate application of the UTMA guidelines.
Are there any other crucial points to emphasize regarding UTMA and SSI?
Regional variations are significant. The legal age of majority differs by state, and regional offices may have specific instructions. Always consult regional guidance for accurate application.
In practice, what advice would you give to someone navigating this complex area?
Seek professional guidance. The interaction between state UTMA laws and federal SSI regulations is intricate. Consult with a qualified professional to ensure compliance and avoid potential issues.
That's a great discussion. Thank you for clarifying the complexities of the UTMA and its impact on Social Security benefits.